Лена, у вас будет презентация, да, какая-то? Дать вам права?
Are you going to have a presentation? Do you need the rights? Yes, please. I will have a few slides to show there in English. I can do screen sharing. Okay. Good afternoon. Today is May 21st. It is our 17th meeting. I forgot what day it was. So we'll be talking about torture prevention and prevention of mistreatment. This series of discussion is dedicated to the implementation of the concluding observation of the Anti-Torture Committee provided last year based on our country's report to the Anti-Torture Committee. The discussion was initiated by the Torture Prevention Association and our organization Kadir Kasiyet. It was promoted by Elena Steinerte, who's been with us this whole time, which we are thankful, and we have received support from other organizations such as MACT, International Torture Victim Rehabilitation Council, and others. We also have our partners in Гражданская солидарность, Civil Solidarity, and today we are discussing the complaint mechanisms in places of deprivation of liberty. Let me present Elena Steinerte. She used to be head of the UN group for arbitrary detention. And usually our discussion will last an hour or maybe an hour and a half to two. Our expectation is an hour and a half. We also have interpretation provided by Yaroslav Shtirbu. That is me. So you can push the interpretation button and choose a language. And now, Elena, the floor is yours. What international safeguards do we have? So you'll have 7 to 10 to 15 minutes if necessary. So the floor is yours. We have up to 15 minutes. After that, we'll have Q&A, and then we'll give the floor to anyone who is willing to have it. Thank you, Anara. Good afternoon, ladies and gentlemen, colleagues, friends. It's my pleasure to be here with you today yet again. I will have some slides to show you. They're in English, and I will also be delivering in English. I find it easier to do it in English, so please do push the interpretation button if necessary. And now I will share my screen. Can you see my screen? Yes, we can.
And so, dear colleagues, once again, good afternoon. It's a pleasure to be with you all once again on this already 17th discussion around the issues surrounding the implementation of the concluding observations of the Committee Against Torture in respect to Kazakhstan. As previously, we are making a kind of a tour through these concluding observations and examining specific issues contained therein. And as Madame Ebrayeva very promptly introduced, today the topic of our conversation is the system of complaints, and particularly the complaints mechanisms as they are pertinent in place of deprivation of liberty. From the outset, I would like to underscore that actually when it comes down to complaints mechanisms, within places of deprivation of liberty and those that might be existing outside of places of deprivation of liberty, there are no enormous differences. And I think this is very important, sometimes an element which is perhaps skipped over, but I think it is important to stop and pause and reflect. Why is it so that the complaints mechanisms which ought to be available to detainees, to people deprived of their liberty in all sorts of places of deprivation of liberty, why should they be exactly the same as those which are available to any one of us who is not deprived of liberty? And I think the answer is very simple. There is no reason for difference. And the reason why the Committee Against Torture is particularly looking at it is that, of course, when somebody is deprived of his or her liberty, that individual may find it particularly challenging to lodge a complaint. There could be a whole host of objective, subjective, personal reasons why this individual might not feel that they can complain or ought to complain. And the whole idea of the availability, accessibility of complaints mechanism to these people who are detained or who are deprived of their liberty is this particular situation of vulnerability of these individuals, their vulnerability, particularly towards torture and other forms of ill treatment, inhuman or degrading treatment or punishment because of their circumstance of being deprived of liberty. And the point of the Committee Against Torture, and indeed of the Convention Against Torture, is to emphasize that irrespective of where you are, what circumstances you might be, even in those cases when you are deprived of liberty, you should have access to effective complaint mechanism, which should be exactly the same as is accessible, available to anyone who is not deprived of their liberty. Why is it, where is this obligation stemming from? And of course, the core, it's the whole raison d'etre of Convention Against Torture. It is to ensure that there is no impunity for anyone who perpetrates torture, who perpetrates ill treatment, inhuman or degrading treatment or punishment. And in order to achieve this, eliminate any possibility of impunity, the ability of individuals to bring forward complaints and corresponding obligation of the authorities to take these complaints seriously, to investigate them promptly, effectively, with the view of bringing the perpetrators to justice when that is appropriate, indeed serves the whole purpose of eliminating impunity and ensuring accountability for the most heinous crime of torture. Where we see it particularly anchored, and I have written out for you the two articles of Convention Against Torture, Article 12 and Article 13. And I think it's also very interesting that when examining state reports, Committee Against Torture usually tends to take these two obligations, these two articles together, which also indicates the interplay between these articles, that one is complementing the other, and therefore an invitation, suggestion to the states that they need to treat these two obligations and ensure their implementation in a mutually inclusive manner, so as to make sure that the complaints mechanism is in every country. So Article 12, and I shall read it out, that each state party shall ensure that its competent authorities proceed to prompt and impartial. Two words that we will be returning a number of times today. Prompt and impartial investigation wherever there is reasonable ground to believe. Now, this is the trigger point which must trigger action vis-a-vis a complaint received by the competent authorities of the state party that they need to investigate allegation of torture. And please, especially the criminal lawyers among us, I'm sure will notice that we are not talking about beyond reasonable doubt in terms of the standard of proof. We're simply talking about prima facie case, allegation of torture and ill treatment, where there is reasonable ground to believe that an act of torture has been committed in any territory under the jurisdiction of the state. And Article 13, each state's party shall ensure that any individual who alleges, not proves, but simply alleges that he has been subjected to torture in any territory under the state's jurisdiction has the right to complain to and have his case promptly and impartially. See the relationships between exactly the same language in Article 12 and Article 13. The right to promptly and impartially examined by its competent authorities. Steps shall be taken to ensure that the complainant and witnesses are protected against all ill treatment or intimidation as a consequence of his complaint or any evidence given. So this, the final bit, is the guarantees against any reprisals that might, any adverse treatment that those who have complained might suffer as a result of this complaint. And what this provision makes clear that is completely, should never be allowed under any circumstances. Now, if we try and unpack these elements under Article 12 and 13 in relation to the complaints mechanisms, so I have two more very short slides, and I hope that with the help of the jurisprudence of the Committee Against Torture, we can unpack a little bit more what does such words as prompt investigation, impartial investigation, reasonable grounds to believe, the right to complaint, what does it mean in practice from the jurisprudence of the Committee Against Torture? So first of all, when we talk about investigations and complaints mechanisms, there are three key elements that the jurisprudence of the Committee Against Torture clearly underscore. First of all, it is the effectiveness of the response to the complaint that has been received. It means, first of all, that the response by the authorities in terms of initiating the investigation must be prompt. In other words, without an undue delay. Now, what does it mean? Would a delay of, I don't know, a month or 2 months or 1 year, at which point in time would the Committee Against Torture consider that the requirement of promptness has not been met? And I'm sure it will come as no surprise to you to learn that there is no strictly set time limit, because what is prompt in each case will be determined by Committee Against Torture on a case-by-case basis. So if we look at jurisprudence of the committee, we have seen that there are cases where 15 months from the time of receiving the complaint to the initiation of the actual investigation has been considered by the committee to be too long, not meeting the requirement of promptness. But we have also seen cases where mere 2 months of delay has not been seen by the committee as meeting the requirement of promptness. So what I think is important to remember is that the committee will actually scrutinize what actions the state authorities have taken. Could they have acted more promptly, more effectively in terms of responding to the complaint that has been received in order to ascertain and determine whether the requirement of promptness has been met? Effective also means that the investigations must be thorough, they must be exhaustive, and they must be competent, which means that the examination must take place of all available materials, making full use of all expert reports, including forensic reports. These quite often need to be ordered in order to ascertain as to whether the issue reaches the threshold of ill treatment or torture. All of this needs to be done, and conclusions need to be arrived at in a consistent professional manner. So this is not something that sometimes in Russian is called tyaplyak. This needs to be a professionally conducted investigation. And here I wanted to very briefly remind us all, I think we already mentioned this case a number of times, Yugoslavian case from the very end of 1998, case of really terrible death in custody of a young man, Mr. Ristich, following which his mother lodged the complaint about his treatment in police custody. Now, investigation was ordered on the basis of the complaint that was received from Mr. Ristich's mother. However, in that particular case, there were contradictions between the report that was received from the doctor, between the autopsy report, the following two forensic reports also contradicted. And all in all, this investigation was ongoing for 6 years, and no reconciliation was possible for the authorities to arrive at the plausible explanation for the death, the reason of the death of this young man. Now, when the case came before the Committee Against Torture to ascertain, inter alia, when looking at the obligations of Yugoslavia under Articles 12 and 13, the committee stated that the investigation has not been thorough and exhaustive, because at the moment when the authorities, when the investigating bodies were faced with these contradictory reports from various professions, there was no attempt to order further investigations, further examinations, so as to attempt to reconcile these contradictory reports and arrive at a conclusion. So this report, I beg your pardon, this investigation was effectively dragged across a considerable period of time, 6 years, where no conclusive reason for the death of this young man was put forward by the authorities. And in the view of the Committee Against Torture, this did not meet the standard of Articles 12 and 13 of the Convention Against Torture. Effectiveness of investigation or response to the complaint also means that this is an obligation. In as much as individuals have the right to complain, it makes perfect sense that therefore it is not an option for the state authorities as to whether they respond to this complaint or don't respond to this complaint. Quite a few decades ago, this was an issue in France where the prosecutors had a discretion as to whether to initiate the investigation on the basis of complaint or not. And according to the Committee Against Torture, this does not meet the standards of Articles 12 and 13, because it's not an option to investigate, it's an obligation to investigate. Any credible allegations of torture and ill treatment simply must be investigated and not left to the discretion of the authorities. Moving on, in terms of the investigations, we're talking about reliability and the comprehensiveness of the investigations that need to take place. In other words, these are investigations that have to be conducted to the standard that would be capable of leading to the identification and prosecution, trial, and punishment of perpetrators when findings so warrant. In other words, when the authorities are investigating these allegations of torture, it is paramount that it is done to the requisite standard of proof, which will then withstand the prosecution and the possible subsequent trial. And finally, I think it goes without saying that any investigation must be fully independent. It must be free of any discrimination, free of any political biases or other types of interferences. They must be carried out in fully impartial and independent manner. And of course, if it goes to the stage of prosecution and trial, the independence and impartiality of judiciary becomes of particular importance. Now, this is more in terms of what the elements of effectiveness, reliability, comprehensiveness, fully independent. This is what happens once the complaint has been submitted. But if we look at the point of what before that, that is the complaining, the very possibility of bringing the grievance, the allegation of torture or ill treatment forward. We need to look at the complaint system and how this needs to be configured in order to give full effect to the right to complaint, which of course serves the fundamental aim of the eradication of impunity for any alleged perpetrators for acts of torture and ill treatment. And how do we achieve this? Above all, it is about the accessibility of the complaints mechanism. And this involves such fundamental questions as how and where individuals can lodge complaints. Anyone, and especially those who are in situations of vulnerability situations which are particularly conducive to torture and ill treatment, such as situations of deprivation of liberty, all of those individuals must have unhindered access to such independent complaints mechanisms in the same way as any one of us who is not deprived of our liberty would be able to complain and make use of. It is a question of how well these complaints mechanisms are known. Do your detainees know their rights? Do they know how to stand up for their rights? Are they enabled to submit the complaints in the confidential manner? And once again, I underline, this is the specific situation of vulnerability of persons deprived of their liberty, why it is particularly important that they are enabled, fully enabled, to make use of the complaints mechanisms. There is also such practical elements as to how complex perhaps the lodging of complaint is, starting from such matters of whether you need to pay for lodging a complaint, whether there is a specific form that the complaint must follow, or an individual is simply able to write freely without afterwards his or her complaints suffering some adverse consequences because it wasn't, the layout of the complaint wasn't according to some specified format, which all makes the complaint system cumbersome and arguably also inaccessible to certain categories, such as, for example, individuals who don't have the requisite degree of literacy. Do you need a lawyer to lodge a complaint? You cannot make your complaint system so legally complex and difficult that a mere layperson is unable to access this. It is a question of confidentiality and transparency of complaint system. And especially, I think the element of transparency is quite often misunderstood. Of course, when the investigation is ongoing, it is natural that certain elements of that investigation, examination of the complaint, will be subject to a degree of secrecy because it's the secrecy of investigation. It makes perfect sense. But at the same point in time, it cannot be such that the complainant is completely kept out of the process and is unable to even ascertain as to how the complaint and investigation is progressing. The whole point of confidentiality and transparency of the complaint system is to ensure that there is a fostering of trust, that the individuals, complainants, feel that they can lodge the complaint, that it will be taken seriously, that irrespective of how possibly high-ranking the alleged perpetrators might be, that the complaint and allegation from a mere mortal individual will be taken seriously and will be investigated thoroughly. And this brings me to this, what I have called in my presentation, the trigger point, and I very much do so in inverted commas, because on what basis, what the complaint needs to contain in order for the complaints investigative machinery to start churning its wheels, so to speak. And here it's very important. The Committee Against Torture has made it absolutely clear in its jurisprudence. Every allegation of prima facie case must be investigated. Anytime when a reasonable allegation is made, we're not talking about beyond reasonable doubt standard of proof or criminal investigation standard of proof. Any credible allegation must be investigated. I'll give you two examples here. One is the beginning of 2000's case from Tunisia, where an individual following detention period alleged that he had been ill-treated whilst in detention by Tunisian authorities. Now, he made this complaint in front of the magistrate and requested that a medical examination would be carried out. Now, the magistrate, on the other hand, refused this medical examination, stating that the individual in question bears no visible signs of traces of violence. Now, as far as the Committee Against Torture was concerned, this failed to meet the requirements of Article 12 and 13, because individual had been in detention, presented a coherent account of how he had been treated in that detention, and therefore was entitled for the court to have this medical examination ordered in order to ascertain whether further steps needs to be taken in relation to the treatment or in relation to any allegations of torture that this individual was taking. And the Committee of Torture made it very clear in that case that any allegation of torture, especially in the context when detention is involved, is serious enough to trigger the obligation of the state to look and examine these allegations seriously and thoroughly. It is also an obligation in some circumstances, which is triggered without a complaint. So this stems from one of the most famous cases, again, was in Yugoslavia, again, beginning of 2000s. A complaint which was brought by some 60 plus Roma origin individuals. There was a really terrible case of one young girl being raped by two members of another ethnic group, and then that one ethnic group retaliated against the ethnic group of where the alleged perpetrators of the rape were. And as those who were retaliating entered the settlement of these Roma individuals, they were throwing stones, there was violence, there was quite terrible things happening. And the police simply stood by and watched this retaliation without interfering in any shape or form. And when the case came before the Committee Against Torture, the committee stated very clearly that in this way, the state authorities' obligation to investigate was triggered even in the absence of any official complaint being lodged, because the authorities observed and had enough evidence at their disposal, which triggered their obligation to act. And finally, and I will not spend too much time on this because I think it goes without saying, is that this element in Article 13 is the guarantees against reprisals. No complaint system will ever be effective if individuals will be fearful to lodge complaints because of their fear of reprisal, of adverse treatment. And this especially goes to those who are in places of deprivation of liberty. The power balance in places of deprivation of liberty already it's not equal. As a detainee, you are by and large at the mercy of those who are running the place. And therefore, you need to have quite a bit of pluck to be able to stand up and complain about the treatment. And it is then you are left in the same place, possibly at the mercy of the very same people who may have ill-treated you. So it is very important that there is the guarantees against reprisals, against any adverse treatment, against those who complained, are effectively guarded against and ensured that that does not take place. As a final point, I wanted to just very briefly, especially since Asger is not here, remind all the colleagues of the Istanbul Protocol, which also looks into the investigation of complaints and the standards around it as an international document, which most certainly must be taken into account. So I stop here and I look forward to any comments that you might have. Thank you.
Благодарю вас, Элина.
Thank you, Elena. I guess now is the time for questions. Today we're discussing complaints mechanisms in places of deprivation of liberty. And as Elena Steinerte has said, we need to pay attention to the three key provisions. The first is there is a standard for handling complaints, that there needs to be impartiality, effectiveness, and promptness. The second is that there needs to be no pressure on the victim. And the third thing is that there are provisions laid out by other documents. So, for instance, we have many international agreements that give a lot of information on complaints mechanisms, how they're supposed to work, and they describe that there are both judicial and non-judicial mechanisms, and oftentimes the latter ones are the weak link. That there are states that have those, and there are states that don't, or even if they exist, they're not accessible to the victims. So what is the situation in Kazakhstan? Today we'll be discussing how complaints are filed in our country, how they are handled. And we know that this has to do with several rights. The first one is freedom from torture, which is Article 9 of the Pact. So whenever a person is detained and until they are released, they will have this right, because in this particular case, we are talking about places of deprivation of liberty. And by such place, we mean a place that one is unable to leave. Besides, in Kazakhstan, we also have a special mechanism, the National Prevention Mechanism, which is used for places of deprivation of liberty. And this is a mechanism that is used by the Ministry of Internal Affairs, the National Security Committee, the Ministry of Labor, Ministry of Health. And apart from the right to personal freedom, it's also a means of personal protection, because it guarantees you due process. And I think we need to pay more attention to the system we have in Kazakhstan and its effectiveness, because once we've analyzed what system we have in Kazakhstan, what institutions we have, then we'll be able to compare the mechanisms available to people in places of deprivation of liberty and ones outside of those places. So now I will give the floor to anyone who is willing to give a comment or question. I see that at least half of the participants are civil servants. We have a representative from the National Ombudsperson Office. We have human rights advocates as well. And I think Alexandra wants to have the floor. Am I correct? Alexandra is a journalist. Yes, hello. Pleasure to be here. I'm a journalist, human rights advocate, and earlier today I called Anara and shared my pain. So since 2016, I've been part of the human rights advocacy system. I became part of the NPM. Back in the day, I was a participant, then head of the group, later left it and became chair of the Public Observation Commission. And I think you know what we do. And yesterday was the first time since 2016 when I was humiliated at an institution for people sentenced for life. In Житомира. So, first of all, I think everything that happened is an example of things that make human rights advocates' work very difficult. It seems like the government officers want to set an example to show that human rights advocates will do their bidding. So what happened is that yesterday and prior to that, I started to receive many calls asking me who is going to do this institution visit, with whom, and it was on Thursday that the authorities received information from us that we have an intention to do this visit. After that, they started to give us many calls, send us letters every day, on and on. And finally, yesterday, my colleague, another member of our commission, and I arrived at this institution. Why did we go there? Because we have received 2 complaints asking for a meeting with a member of the commission. So we were searched through and through. They even made me take off my bra. They made me take off my trousers. So basically they searched, they almost searched my insides. And I made a copy of that warning. They had me sign it, and this warning says that here is a list of items you are allowed to take into the institution. And I said that, well, I do not have anything on me. No books, no razors, no games. Why am I to sign it? And this warning also says that you are not supposed to bring any drugs or alcohol. And I asked them, so why is it that you want me to sign it? So does it mean that if I, for instance, have some drugs on me and go in without signing in, that I will be free of responsibility? No, because there is criminal legislation for that. So all in all, they force you to sign this paper, and this paper is not aligned to the criminal code and to the provisions on the activities of the commission. But okay, fine. You go in, you get searched, things happen. You sign all those papers. Okay. So I had a person who wanted to meet me, and I told them, here's the person I'd like to meet. That person had some issues related to being released on parole. So thing is, they owe the state 3,500 tenge, and this is what makes them eligible to file for being released on parole, which is ridiculous because it's just 3,000 tenge, and this is quite unexpected because it's due to something that happened 15 years ago, and that prisoner is saying, I would like to pay that, how can I do that? And they say it is impossible. This is case one. Case two, I was contacted by the mother of a prisoner, said that the prisoner would like to meet a human rights advocate, and that was number one. And number two, I wanted to meet with Mr. Ibrahimov. As it turned out, that after I contacted the authorities, Mr. Ibrahimov wrote a letter saying that I would like to have limited contact with human rights activists. So why would he file a thing like that? And why did he search me? Previously, when I went to that institution before that, I did it as a journalist, and I took an interview from Mr. Ibrahimov, Rinat Ibrahimov, which was published in many media, and that resulted in many people losing their positions, including head of that institution. So Sargazinova, that is me, went in and did that interview, and some people had to resign. And I told them that I would do an interview with prisoners, and I started doing it. And as I talked with Mr. Ibrahimov, who had been sentenced for 18 years for murdering Altenbek Sarsbayev and his two bodyguards, he told me about his case, that all these years he had been unable to have any visitors, and that the officers will only allow national security officers or government officers to visit him, and he'd been doing time for 18 years, and he looks sane, he looks rational. However, he's not provided any opportunities of communicating with the outside world. And I've been the first journalist to do an interview with him. I published it in a Telegram channel, and that has resulted in me being obstructed yesterday in my activities. So this is what I have to say. And the picture I have in my mind is that Mr. Ibrahimov is kept in that institution unlawfully. He is not provided any opportunity for communicating with human rights advocates. And I've been working for many years doing advocacy, and not once have I been able to enter his cell. So each time I went to his institution, he had been forcefully removed to some other institution. And yesterday, having been addressed by his brother, who asked me to take a look into his case, I believe that what happened yesterday was unlawful. Means they have something to hide. So here's my story, the events of yesterday. Thank you, Alexandra, for sharing. Indeed, this case has to do with several provisions. The first one is the status of people exercising public control in places of deprivation of liberty. Second one, safety of human rights advocates, that they are not supposed to receive any threats. And we have special provisions for that enshrined in UN documents such as the UN Advocacy One and the San Jose Principles. And those aim to make any repression against human rights defenders impossible. Another point I have is so the signals you receive, the people that address human rights defenders, they believe that the conditions in which their relatives are kept are not in line with the Kazakhstan legislation and national standards. Another one is that people in detention, they are isolated from society. At the same time, they're supposed to have all the other rights. And under the Kazakhstan legislation, of course, there are certain limitations. For instance, you are not allowed to take part in elections or to run for certain offices. However, you have the freedom of expression, you have the right to have visits, to make phone calls, have the right to do interviews with mass media. And some of them claim that they're innocent, which means that they disagree with some judicial rulings and they would like to express their position, and they have the right to do so. This is a guarantee that everyone is supposed to enjoy. And yes, we could give the floor to Elena to address that situation. Maybe you could clarify what rules are supposed to be used by government officers when searching human rights advocates, and to which and how, what are they supposed to do in terms of ensuring their freedoms and excluding any humiliation, because Alexandra says that she was humiliated yesterday. And I think that you don't have to be a lawyer to see that you've been humiliated. So in that context, are there any standards we could refer to? Because the way I understand it, Alexandra means to give profile to what happened to her as a woman, as a human rights advocate. And besides, I think once people will have heard something like that, they will think that they wouldn't like something like that happen to them, and that may strike a blow to the activities of the commission. Elena?
Сперва, Александр, мне очень жаль, что такое
First of
произошло.
all, Alexandra, I'm very sorry.
In my position, I would not like to comment on an individual case, but just to, as Anara asked, I would like to offer some general points for your consideration. Firstly, places of deprivation of liberty by their very nature are closed institutions. And as we know, torture and ill treatment doesn't happen usually in the broad daylight. So therefore, when you have a closed institution, the circumstances are set ripe in a way for torture and ill treatment to take place, because by their very nature, such acts usually take place behind closed doors. And this is a very clear recognition of international community that that is the case. And this is why we have instruments such as optional protocol to Convention Against Torture, which is premised upon the idea of breaking down these closed doors to the extent so that torture and ill treatment would be less likely to happen. And this is where the culture of independent monitoring and oversight is absolutely paramount, that there is an understanding from state authorities that it is what it should be, that independent oversight over place of deprivation of liberty takes place, and that it takes place in a constructive manner, and that it is welcomed by the authorities, because that independent oversight helps the authorities minimize the risk of torture and ill treatment taking place, which is their obligation under Convention Against Torture. Now, in this way, the culture of independent oversight, and I specifically intentionally use word culture, because I think it makes it clear that it's not something that magically appears in places of deprivation of liberty overnight. It is something that needs to be fostered, worked at, and created in country. And it usually takes decades, I'm afraid. It is not an overnight process. And therefore, elements that we see how independent oversight, people who carry out independent oversight, are openly or covertly impeded in their ability to exercise this oversight. We see a whole plethora of tools, mechanisms, approaches, invasive searches being one of them, as methods and ways of how to crawl back this independent oversight. And by its very nature, the light that this independent oversight sheds into the darkest corners of places of deprivation of liberty, with the ultimate aim of preventing torture and ill treatment. This is a very difficult situation to break down. Now, Anna, you were asking me of international standards in relation to the civil society, гражданское общество, oversight. And I'm afraid that when it does come down to civil society, aside from the Declaration on Human Rights Defenders, we don't really have, strictly speaking, legal standards. What we do have is the optional protocol to Convention Against Torture, which talks about the oversight and in preventive visits carried out by national preventive mechanisms, which also can contain members of civil society, as you very well know in Kazakhstan. And there are guarantees against, for example, invasive searches, privileges, and immunities that also members of the NPM, as well as of the SPT, ought to have when they carry out their work. So that's one set that we have. What I think is also important is to understand that at some point in time, the tools at disposal of place of deprivation of liberty, such as granting access, the security rules which are imposed vis-a-vis certain regimes of prisons, for example, or certain categories of prisoners, searches that are carried out. All of these need to be implemented in a manner which is reasonable and proportionate. And these are the elements that we also see weaving through all the Mandela rules in relation to the treatment of the prisoners. This idea of proportionality and necessity of whatever regime is being imposed. And I think by analogy, we can also talk very similarly when it comes down to public oversight over places of deprivation of liberty. Is it really necessary and proportionate to strip a civil society monitor down to the underwear as the person is entering place of deprivation of liberty? Is it really proportionate and necessary? And how can it be justified? On what basis? That risk assessment needs to be carried out and it needs to be transparent. And if indeed there is at some point in time a reasonable ground on behalf of the authorities to suspect that a member of civil society might be smuggling something in place of detention, place of deprivation of liberty, then please show it. And this, I think, is an element that could be challenged. So I'll stop here.
Спасибо большое. Я вижу здесь наши
Thank
коллеги
you.
из Монголии, да?
We have
Если
a
я правильно
colleague from
понимаю,
Mongolia who raised their hand.
Бояр Гевасамбу.
Delger Bayar
Вам слово.
wants to have the floor. Delger Bayar, the floor is yours.
Да? Что-то не слышно.
Меня слышно?
Все, сейчас слышно. Мгм.
Хорошо.
Can you hear me? Yes, we can.
Спасибо вам, Елена Штейнер. И хочу
Thank you,
начать
colleagues. Thank you, Alina.
Меня зовут Изгар Бояр. Я
First of all, I'd like to introduce myself.
сотрудник ENG в Монголии.
I'm Delger Bayar,
У нас
and
уже 2 года. Мы уже 2 года работаем.
I've been
Ну, точнее, 1,5 года.
working as a member of the
Что и меня
National Prevention Mechanism in Mongolia for 2 years, and
несколько вопросов
I do not have
Елене Штейнеру.
questions per se,
Я давно не разговаривал на русском, поэтому
and
я просто подумал, что если спрашивать на английском, это не
so should I switch? I wonder if I should switch to English or should I speak in Russian? Not entirely sure. I think I'll do it in Russian. So my question is, you said so that the mechanism of independent oversight is supposed to be operational. However, how is it going to be represented at a government level? So are we going to have a government agency doing that oversight, or is it going to be an NGO doing that? The second one, if it is institutions we are talking about, and quite often it will be people that are underprivileged that work there and or kept there,
получается, что
And for instance, when we receive complaints,
после этого отправления подачи жалоб мы
so once the complaint
государственных
is filed,
которые отправили,
we will
сказала, что
address the
несмотря
government authorities and they will tell us that they've been working on that, and then 2 or 3 months later, just nothing happens. So what do we do in that case? That under the law, the NPM or Human Rights Commission receive a complaint, they're supposed to contact the corresponding institution within 3 days. So under the law, we have special agencies handling the complaints, the police, the anti-corruption committee. And now coming back to my first question, so if you say that we need to have a special commission or a special body, is there any chance that this committee, so is there any chance that the NPM or commission would be handling this complaint, would be considering it, and because under the law, it's supposed to be the government agencies. And all international organizations say that, well, the complaints are to be handled by the institutions that are described in your law, and according to our law, it is the government agencies. But in this third case, the National Prevention Mechanism and the Commission, what can they even do? The third one, so we have this committee. What is the likelihood that this commission or committee could join forces with us, with the NPM? So, for instance, would they be able to address a complaint? Could NPM be used to address complaints? And I have a colleague who is currently sending questions. She's wondering, if we receive a complaint from, for instance, a victim's relative, and they say that we urge you to address this complaint, we want that you should address it, not government agencies. What do we do in that case? Thank you. Thank you. I see that your colleagues joined in today. Thank you for your interest. Thank you for sharing your practice. Elena, we have a representative of the Ombudsperson office, Alexander Terena, here, who's been working at the National Prison Committee for a long time. Shall we give the floor to Alexander? Yes. Good afternoon. I'm trying to have my video on. Somehow it doesn't seem to be working.
Видим, ага. Хорошо, вас видно, теперь мы знаем, кто вы.
Да, так легче воспринимается информация.
I think
Всем еще раз
it's better now.
Меня зовут Александр
Good afternoon.
представитель
My name is Alexander.
Национального центра по правам человека.
I'm a representative of the National Ombudsperson Office,
Поделиться информацией, что
and I would like to give some
в
information.
2023 году в адрес
In
уполномоченного
2023,
его представителей
our
поступило около
office
40 000 обращений.
received
Полтора раза
6,000
больше,
complaints,
чем в 2022 году.
which is 50% more than we did in 2022. I think that was thanks to our
Необходимо отметить, что
offices established,
тенденция
having been established in the regions,
существенное нарушение
and we see that
процессуального законодательства. Вторая
complaints mainly address violations of the
согласие с судебными
criminal and procedural
актами.
code.
Третья
The
группа,
second
здесь жалобы
most
на
popular
нарушение права
group of complaints is
Количество увеличилось в 4 раза.
has to do with sentences, and the third is the rights of people behind bars.
Большой блок
It
вопросов
saw a major increase,
наказания,
and we see it as a
неудовлетворительные условия содержания,
diverse group. So bad medical services, disagreement with a disciplinary punishment,
и удовлетворение ходатайства о досрочном освобождении
denying
заменить этой части более мягким видом наказания.
parole release,
Необходимо отметить, что
denying
присутствуют такие жалобы,
other
как
softer means of punishment,
по
and
подаче жалоб.
among others,
Есть
we
примеры,
have complaints
отражается
related to
деятельности
lack
уполномоченного
of
по правам
access to complaints
человека.
mechanisms.
2023 год более подробно с
And
данным
we
докладом можно ознакомиться на сайте уполномоченного по правам
reflected that situation in our report for 2023, which is available on our website.
пыток и жестокого
As for
обращения.
torture and mistreatment,
Я полагаю, что есть ряд
there is
свобод,
a
которые
number of
ни в коем случае
rights
не
and
должны быть
freedoms
ограничены, независимо от того, в каких
that
условиях
are
находится человек.
not to be restricted
Гражданское ведомство,
no matter
то уголовная
where you are,
система,
in a civil institution, in a
это право на
police station.
применение в отношении лица
For instance,
жестокого обращения.
you have the right to be free
Не
of torture and mistreatment. It is inalienable,
равносильно, что запретить человеку
and
дышать,
I think
вообще думать.
this is in line with the right to breathe, with the right to think,
Проводимого нами мероприятия,
and we
думаю, что место лишения свободы
believe
надо
that
воспринимать не буквально, а более в широком его
places of deprivation of liberty need to be seen
пенитенциарная
broader.
система, то есть
So it is
буквально
not
воспринимать
necessarily a
связанные
prison, but
с
any closed
исполнением
institution.
наказания. Но
So usually people think that
в большей степени это
place of deprivation of liberty is a prison, but we believe that it's any closed institution, any
и находясь в
place
таком
you are
положении,
unable to leave
должны быть исключены все факторы,
despite the fact that you
связанные с
want
применением
to.
в отношении данного лица,
And I think
даже намека на применение пыток или жестокого обращения.
that if someone is kept in an institution like that,
И их совершенствование
it is our duty to have safeguards against torture and mistreatment. However, when it comes to complaints mechanisms,
в области прав человека и верховенства закона
we've raised that issue earlier.
в декабре 2023 года есть
We have a
мероприятие,
law
это
from
разработка
December 2023
процедур подачи.
that says that effective
Призвано это внимание государственные органы
complaints filing mechanisms need to be developed, and I think government agencies
написания обращений, жалоб,
have been working on that, because traditionally we have had
терминалы. Но
the,
надо признать, что
such mechanisms as
что эти терминалы
filing written complaints and using terminals, but
Поэтому здесь необходимо реагировать.
those terminals do not always work,
Также
and
участники национально-превентивного
this
механизма,
is something that we've been
независимый механизм, который об этом,
tackling.
тоже имеют представление.
Besides, we need to have an independent mechanism,
При личной встрече ориентировать, чтобы все
and
механизмы
whenever
закрытых учреждений, не только пенитенциарной
we meet with government officials, we always emphasize that these complaints mechanisms need to be put in place in any institutions, and our office will continue to take all measures necessary in encouraging government officials to be mindful of that. Thank you. Could you give a short overview? So what is the timeline for complaint handling? So can be provided in written form or digitally? Is there anything I'm missing? So how long does it take for you to handle a complaint? So how quickly are decisions made? Well, you are correct. So the first one is we receive letters when we do personal meetings. Then we have digital resources such as e-Otenish. So this is information we receive from institution administrations. Also we receive information from our representatives at the institution. The timeline is 15 working days. Usually it is dependent on the type of issue raised, whether it is easy to resolve or not. If necessary, it could be prolonged to 3 months. So it depends. Thank you. If anyone else would like to give a comment or question, I'd be happy to give you the floor. And now we have 3 questions. Let us address the 3 questions from Mongolia. Ms. Steinerte, the floor is yours. Thank you, Anara. Thank you, colleagues from Mongolia.
So talk about the independent mechanism in terms of the complaints mechanism and investigative mechanism. In the context of Article 12 and 13 of Convention Against Torture, these are provisions talk about competent state authorities. So what is very clear also from the jurisprudence of the Committee Against Torture is that we are not talking about non-governmental bodies. It is the state obligation to ensure investigation. It is the state obligation to ensure effective complaints mechanism. And it is the state's bodies, therefore, which need to investigate. Of course, there are other bodies such as human rights commissions, ombudsman's offices, other bodies which also could work in a similar way. But that does not detract from the obligation of the state to own this investigation. And what is, however, important is perhaps the element of impartiality. So we had a classic example that always comes to mind was the 2006 visit of the UN Special Rapporteur to Jordan. And the Special Rapporteur against torture was, during this visit to Jordan, informed that they have very little allegations of torture and that there is effective investigation of all allegations of torture or ill treatment made. And when the Special Rapporteur looked into these mechanisms, it turned out that all the complaints in relation to police are investigated by police. All complaints in relation to intelligence authorities and security are investigated by the same authority. All allegations in relation to prison are investigated by the court decision enforcement authorities, basically the prison authorities. In other words, the investigations of all complaints were kept within the same units and ranks so that it came to almost a de facto situation, which we know in Russian, ruchka ruchku moyet. Yeah? And therefore, the element of impartiality of this investigation was completely devoid in the situation. So what we see from the jurisprudence of the Committee Against Torture is that it is advisable not to entrust investigations solely to persons who have close personal or professional links with the persons who are suspected, who are alleged to have committed these acts of torture or ill treatment, or who may have some sort of interest in protecting these people. We are talking about a situation where there is a kind of a distance between those who are alleged to have been perpetrators of the torture and ill treatment and those who are investigating. And it needs this impartiality, the quality of this investigation is really the key rather than the body, shall we say. So it is about how this impartiality element is ensured in practice. And this is the crux of the matter, really. What is, though, very important also, aside from this impartiality, is that whoever is investigating is able to carry out full investigation. It cannot come to a point where the state authorities have appointed a body to investigate, and then it turns out that, I don't know, for example, this body cannot access documents from the state intelligence service because there is state secrecy around whatever state security agencies are doing. That's not going to sit with the requirements of Articles 12 and 13 of the Convention. So the core element really, I suppose more so than independence, is the question of impartiality of investigation. Now, your second and third questions, if I may sort of take them together, if I understood correctly, what you were asking is the role of the NPM in the complaints mechanisms and how to deal with sometimes situations when an NPM is approached with a complaint and what to do with that complaint. In practical terms, it's a very difficult situation. I myself, having been in prisons around the world, I am often approached as well and said, I only will trust you because you come with a UN blue vest. I can only give my complaint to you. And as torn as I have been in those situations, I have never taken a complaint from individual in those circumstances because I don't have the mandate to do that. And I think it is also very important, and I think it comes also part of that fostering of trust relationship that I mentioned, is that if you are representing an organization which cannot take the complaints, that you make it very clear. Of course, there are different ways of making it clear. You know, you can also lay people down gently in a way, but it is important to explain the remits of your mandate. And in my experience, when that is explained, some people get really upset and they don't want to talk to you anymore. But the majority still want to talk and still want to engage. They understand that perhaps this is the remit of your mandate, but that's fine. And they still are willing to proceed with the interview and talk to me. From the perspective of the NPM, however, I think what is very important also is if there is this consistent approach from individuals saying, we can only trust you, we don't trust this other complaint mechanism, whatever that might be available in your country. For me, if I was a member of the NPM, the question would be why? Why is it that you don't trust this other complaints mechanism? What is it with this authority? And this, I think, is a crucial part of the preventive work of the national preventive mechanisms, to also look into the effectiveness of the existing complaints mechanisms. Are they working? Are they accessible? Are they effective? Do alleged victims have confidence in these mechanisms? And if the answer to any of these questions is no, then this is about thinking about targeted recommendations towards the authorities as to how to strengthen, how to perhaps reform, what changes need to be done to foster better machinery of this complaint mechanism. It's not something that is to be, done overnight. but then none of the NPM's preventive work can be complete overnight. This is a very long-term process and would require a thorough analysis. Where are the weak points and why the particular complaints mechanisms are not being utilized? So that would be my suggestion. Thank you.
Спасибо, Элина. Я вижу, что вновь рука есть у нашего коллеги из
Thank
НПМ
you,
Монголии.
Elena. We have another hand. Gerbayar raised the hand again.
Спасибо, достаточно. Спасибо.
Is there anything you'd like to add? No, I just wanted to thank Elena. Thank you very much indeed.
Я надеюсь, я правильно произношу ваше имя, Гербаяр, да?
And am I pronouncing your name correctly, Gerbayar? Yeah, Gerbayar is fine.
Я точно вот знаю и вижу здесь, что есть у нас другие представители
have
государственных органов. Может быть,
other
кто-то из
government
вас доведет до нас
agency
формы
representatives.
и механизмы существуют подачи жалоб.
Is anyone of you willing to give us more information on what complaint filing mechanisms we have? Because, well, there are international requirements on that, on the one hand. On the other hand, if, for instance, a complaint is filed not by the victim or their lawyer, but a relative of theirs or a friend. So in this case, government agencies that address complaints, so they need to be independent, at least nominally. So there needs to be a distance between that agency and the person who files the complaint, and the prosecutor, the judge, and the police must not have any vested interests. And I think these would be raised to the repression that is so common and that people just start to get used to repression. And for instance, Alexander, earlier you said that the number of complaints rose in 2023, and it seems like people started to understand that there is a mechanism for getting redress of their grievances. At the same time, we see, and by we I mean civil society, we see that there are certain practice of impunity, that you file a complaint and then just no result. The rights are not protected, and I'm talking about people behind bars, I'm talking procedures, I'm talking resources, talking arrest. So for instance, Alexander, you mentioned the fact that terminals, which have been quite expensive to install, quite often they are not operational. And also we see undue delays, that it may take up to a month or more to respond to a complaint, while immediate response is necessary. And for instance, if a person is kept at an institution, at a mental institution, not prison, if their complaint is dismissed, it may lead to a dire situation. For instance, you are prescribed a drug which you do not wish to take, and you see that it may have detrimental effect on your health. So all in all, under the UN rules, complaints need to be addressed without undue delay. And the government officials in Kazakhstan know that if a complaint is made on torture, then you cannot prosecute that person who files the complaint for libel. However, and it's a good thing that this has changed, however, even this year, I've seen many cases, and that those people may in fact be persecuted, and we have complaints on that, and often it's very difficult to see what exactly took place. And for instance, if someone filed a complaint, were they persecuted after that or not? It's very difficult to see that, and people are often forced to say that they do not want a lawyer, do not want to do any interviews with media or human rights defenders. And let us get back to the Ibrahimov case, who is has been sentenced for life. It seems like he's been under pressure to write these documents saying that he does not wish to be attended by human rights activists. And I think it is indicative of an entrenched practice. There are other cases like that.
Аннара, с моей стороны, я должна, к сожалению, извиниться, потому что у меня одна встреча, другая встреча
I'm
начинается.
so sorry, Anara, but I have to leave. I have another meeting to attend in 2 minutes, so I guess I do not have anything to add to that. Thank you, Elena, this intervention. However, we will continue. I hope our participants have something to say, something more to say, because so far I haven't received any precise information from the government officers. So could you please clarify what do we have in our legislation? Because our goal is not to say that everything is bad. We want to explain it to the public what safeguards they can use. So what mechanisms do we have apart from addressing the ombudsperson office? So thank you, Elena, once again. Oljas, the floor is yours.
Добрый день.
Good afternoon,
Приветствую участников конференции. Я старший
esteemed
помощник генерального
participants.
прокурора.
I'm Chief Assistant
Непосредственно
to
занимаюсь надзором за
Prosecutor
полицейскими
General.
учреждениями.
I'm the one in
В
charge of
данном случае по подаче
institution
обращений
oversight,
к юридическим лицам. Вот как
so
уже
complaints.
бывший коллега
The mechanism,
Екатерине говорил, да,
as
это
Alexander
терминал.
has said earlier,
В рамках... Меня слышно, да?
when it comes to the terminals, can you hear me? Yes, we can.
Ну вот на сегодняшний день
As of
в
today,
78 поставили 68 терминалов.
have 68 terminals,
Прокуроров на местах, чтобы периодически смотрели их
and
размещение,
we demand that
фактическую их работу. Да, действительно,
prosecutors
есть
should
такие
do
моменты, когда
monitoring
стоят пароли,
of those devices, because
либо
at
там
times
отсутствует интернет-связь.
there will be
Эти факты
a
мы выявляем,
parole
также реагируем
used
буквально
on
в
a
этом году.
terminal, or
Также
maybe
несколько фактов было
there is no internet
в
connection,
субъекты надзора в
and
этой
we have
части, в том числе
identified
учредили
cases
генеральный
like
прокуратуру
that
в МВД. Мы это всегда
and
связываем
raised
с
those,
превенцией пыток.
and we do it as
По
part of
обращениям.
torture prevention.
Механизмов достаточно много.
There are many mechanisms
Ну, как уже сказал, это подача
put in
терминалов.
place.
Да, бывает
First of all is the terminals. Second, we do personal meetings.
Даже после приема этапа,
And
что в течение 3 дней
you do not need to file a special documents. So usually, when you are kept in quarantine, a prosecutor will come and see you to have a talk with you to see whether there is any oppression taking place. Why? Because often we will receive a complaint on a case of torture that took place a year ago or more, which we would be unable to prove. And compared to 2022, we see that the number of complaints decreased, and that's thanks to those prosecutor visits that we've been doing. We also have prisoners' relatives address us, and if it is torture, then we'll initiate the case immediately. We have prosecutors specializing in torture, handling those investigators. So since 2022, torture is being handled by the prosecutor's office. We work under the Istanbul protocol. We've seen some positive shifts. As for the mechanism itself, complaint filing mechanism, I think there is always room for improvement, and we need to see the bottlenecks in complaint filing, because we see that at times it will be the institutional administration putting obstacles. Also, when we meet with prisoners, we ask them to just write a complaint and give it to us. We also have special complaint boxes checked by prosecutors weekly. I wonder, is there any international mechanisms that we could implement in our country? International complaint filing mechanism. We would be interested in learning more about that. Thank you. We have another hand raised. As for your question, unfortunately, Elena is currently unable to respond to you, but she will later. So we'll forward your question to Elena. Guljan? Good evening. I cannot turn my video on. Well, it's okay. Guljan, spouse of Mr. Nurmanov, who is in detention in Astana. So, my husband needs a surgery for a tumor to be removed. We have all the necessary medical papers, and this surgery can only be performed in the National Oncology Center in Astana and in an oncology center in Almaty. And we went to the doctor in Astana and asked to do the surgery, but they said they didn't have the necessary equipment. So in Astana, they said they wouldn't be able to do it. And I also addressed the penitentiary system. They told me they wouldn't be able to give us permission to go to Almaty for that. And what do I do? This is a difficult situation. Besides, it is the third time that a surgery like that needs to be done. So this tumor is very close to the artery, and even Dr. Shalabayev said that my husband needs the surgery and he's been in detention for 6 months under a lot of stress in poor condition, and this tumor as a result has been growing. Because either it turns malignant or it becomes inoperable, which may result in my husband going blind, for instance. So what do I do? And I think this case would be addressed by this meeting. So your husband is having difficulty receiving the necessary medical services. And now I would like to address the government officials, the ombudsperson office. So lack of access to medical services is seen as mistreatment, which is prohibited by the Torture Convention and Article 146 of the Criminal Code. So you have just given us information on a case of torture, and we would like the General Prosecutor's Office to address that, to help you, and maybe you are able to say who we need to address in this particular case. So we've been discussing complaint filing mechanisms. And I know that there are cases when regional ombudsperson office representatives have been providing this kind of assistance. We still have people joining in. We have Rosa, deputy of the head of the Human Rights Committee. Maybe you could give us more information on complaints mechanisms in places of deprivation of liberty. So in this case, we're talking prisoners and people held at mental institutions. However, we also have other groups such as elderly and children. So what is the situation in Kazakhstan with children's complaints? For instance, we have orphans. And I think it is quite possible that at times the orphanages will not make it so that the complaint will not go any further. And we have people not in detention give information about torture and mistreatment, and we see that no responses takes place. And one of our recommendations would be to enshrine the right of a child to file a complaint about bullying or mistreatment. And well, the criminal and administrative code do not say that children are not allowed to file complaints, but we know that if a child goes to a government agency or institution, usually they will be dismissed. So I think that we need to be talking about complaints mechanisms used by different categories of people. And well, there might be some universal ones. And when it comes to torture, I think it could be anything. You could give this information in written form or spoken. Because torture does not require you to file a complaint in written form. It is enough for someone, for instance, to write a post on social media or to just say it, and then it needs to be registered. And why do we still have this recommendation from the previous years? Why is it still relevant? It has to do with the January events. And for your information, many complaints were filed, and we know that many people are still afraid to file complaints. Rosa, is there anything you'd like to add? Rosa or anyone? No one seems to be willing to have the floor. Then I will continue. There is a number of resolutions from the Anti-Torture Committee, from the Human Rights Committee, from the Women's Discrimination Committee, and those resolutions have provisions saying that Kazakhstan has been violating the right to file complaints. I'll give you a case, Oleg Yevoyev versus Kazakhstan. So Oleg is a prisoner, sentenced for life, kept at Berkut, Jetygora, in Kostanay region, and so far it has not been implemented. However, Kazakhstan is to implement that, to take some measures resulting from that. So it means that it's been since years since this recommendation was provided, but it has not been implemented. I think we need to ask the Human Rights Ombudsperson and the Presidential Administration to give explanation for why it is so. Because, for instance, back in 2010, a special mechanism was implemented for how UN resolutions need to be handled. There are timelines provided and government agencies designated who needs to be doing what, when, and how to inform UN agencies that those have been implemented. So we are talking follow-up procedures. How to have control over the implementation of UN recommendations. So once the government officials have received information about that, and for instance, in Oleg's case, his torture complaint was not handled for 6 months, which is a lot of time. So I think we need to start with the timelines and results. It's all about timelines and results, have always been, and we need to think. We need to think about vulnerable people, how these procedures need to be working. Rosa, over to you. We have 14 minutes. Hello, esteemed participants. I'd like to thank Anara for promoting UN recommendations. I'd like to thank Adir Kassiet for holding events like this one. It's important to have platforms like this where we are able to discuss issues that haven't been resolved just yet. As for the complaints mechanism, it is still problematic. So many institutions have special terminals.
Терминалы они называются.
Ой, да, терминалы, я
Yes,
по-советскому, да, терминалы, но они вызывают
they do.
сомнения по поводу
However,
подачи жалоб. У меня, как у правозащитника, который
as a
получает
human rights
жалобы от
defender,
ребенок особенно, это из учреждения уголовно-исполнительной системы.
I'm not fully
То есть,
confident in their
и,
work.
эти осужденные, большинство
So we
из них,
see
к
that
сожалению, не
people behind
обладают
bars,
высшим образованием, либо средним.
many of them do
Понятно,
not
они
have
не имеют
higher
работы с
education.
компьютера, там специальная клавиатура. И более
Many of
того,
them do not
чаще
know
всего
how to
нам
use
жалуются
a
на то, что
computer.
они стоят рядом с
Besides, quite often, those will be installed next to
успеть, ну, в общем, присмотром сотрудников учреждения. И понятно, что
either
многих
cameras
постелей
or
обращаться,
you can
подходить даже к
only
этому
use
терминалу. Многие не умеют пользоваться
the terminal
терминалом.
while supervised by
Наверное, это
an
очень
institution
большой вопрос.
officer. So
И
all in
я
all,
хочу
many
сказать по
people
поводу
are
детских
unable to use
учреждений,
those, and
особенно
it's an issue.
здесь, где находится
As for
полиционных школах,
children's
мы очень много
institutions,
походили, и
for
с
instance,
Анарой вместе
correctional
ходили,
schools,
и с другими участниками НПМ, и
we've been
по
to many of
командам
those
рабочей группы по детям. Это
jointly
вызывает
with
большую
ANARA and
озабоченность.
NPM.
Несмотря на то, что там есть
Those
телефоны,
are a
там
great
есть
concern.
мероприятия
Yes, they
для
have
подачи
phones,
жалоб,
they have
то понятно, что
boxes,
дети, которые
but
имеют разного
children,
рода особенности, да, по здоровью, то,
especially
естественно, они сами не
special
могут
needs
создать.
one,
Другое дело, есть
they're
практика
unable to
обращения
use
через нас,
those.
через другие, я думаю,
So
через
they
детский
may
комитет по правам ребенка,
file a complaint
обращаться в государственные
through
органы.
us,
То есть на жалобу дети сами могут
and
приходить, но они приходят с родителями. Допустим,
for
опыт
instance,
нашей рабочей группы, которая
in
более
our
20
case,
лет по детям, то туда
in our
приходят к
working
нам в
groups,
общественные
working
приемные
groups
дети с
experience,
родителями, и мы
we'll
говорим,
have
ребенок
children
должен
and their
обратиться
parents
к
visit us,
по законодательству
give us
в
question, and we will
государственные
explain
учреждения.
that
Хотя
a
конвенция говорит о
child
том,
may
что
file
возраст не должен быть ограничен,
complaint
потому что мы прекрасно понимаем, что ребенок,
themselves,
все дети
if they're
разные,
10
и
years
дети
or
может и в 7-6 лет высказать свою
older.
позицию
And
и
we think it is
рассказать о том,
wrong
что
that
с ним случилось.
there
Есть
is this
взрослые,
barrier,
которые не
that
могут
there are even children who are able
сконцентрироваться и написать, допустим,
to
жалобу.
provide information at
Еще
the age of
есть
6
много
or
разных
7. At the same time,
вопросов,
there are
особенно
adults who
касающихся
can.
жестокого обращения. И
However,
там, где не могут люди получить,
we still have many
допустим, к нам
issues.
обращалась дама,
For instance,
она
Olga
не может
Shtyk
получить достойную медицинскую помощь, то, конечно же,
just
это
addressed
наказание,
us,
как
saying that
сказала Анара Нурлубаевна, его можно отнести к жестокому обращению. Вот на это
her
очень
husband's
важно
been unable to receive
представители государственных органов, особенно уголовно-исполнительной системы, жалобы
a
по
surgery, and I
этим
think
учреждениям.
these can be
Здесь,
seen as
я
mistreatment
думаю,
or torture.
все понятно.
As for children,
Возможность есть институты, но на сегодняшний день нет
so
такой,
we have
скажем так,
the
культуры, чтобы
institutions,
дети сами приходили и
but
обращались
we
в
do not
государственные
have
органы.
the
Более того,
culture
учитывая, что
for
где
children
находятся
to
эти
go
государственные органы, если взять
to the
даже
institutions
уполномоченную
themselves.
программу семьи,
Besides,
находится в Доме министерства,
for instance,
понятно, что там
the
пропускная система, необходимо удостоверение
human
личности и так далее, которые как раз-таки
rights ombudsperson office
несет за собой
is
ряд других
at the
проблем.
House
Ну,
of
по огромному
Ministries, and to
количеству
get there, need to go through the security checkpoint, which is quite difficult, especially for children. You just won't be able to do that. Thank you, Anara. Thank you.
Я последний раз спрашиваю, если есть у кого-то еще желание
Are there
высказаться,
any
потому
other
что
questions or
некоторые
comments?
рекомендации сегодня прозвучали уже на основе анализа
Some recommendations
практики
have been made
и с
earlier
учетом
today
действующего
based
законодательства.
on our practice
Я повторю,
and
наверное,
existing
есть еще
legislation.
желающие? Господин
Is there anyone
Арыков,
else?
да, пожалуйста, комитет
Azat Arikov,
системы МВД.
Да, позвольте поприветствовать всех. Здравствуйте,
the Penitentiary
уважаемые
Committee.
господа. Сегодня, да, затронута очень
Good
актуальная
afternoon.
тема, которая уже
Indeed,
рассматривается очень давно.
you
Здесь, со своей
raised
стороны, мы также
a pertinent
рассматривали,
issue.
анализ проводили по
And we have conducted analysis for complaints mechanisms, and we see that in most countries they use traditional means for that, and under our criminal legislation we have Article 14. We have a special chapter on visits. As for terminals, the General Prosecutor's Office have launched the e-Otenish system to connect all of those terminals to provide for better complaint handling. Besides, I'd like to emphasize that we will take into account all the issues raised today, and we work in close cooperation with civil society organizations, with NPM. Well, yes, there are issues, but we'll do our best to make the situation, to get the situation to improve. And there are ideas on alternative mechanisms to be used by prisoners and society at large, and we will consider those because our system's been working on implementing international recommendations in our country. We'll take the necessary measures. Thank you. Thank you for your brief response. It's indicative of you being very talented, in line with Chekhov's observation on brevity being the sister of talents. And one more thing, Ms. Romano, Mr. Gardiner will take that into account. As for the second case, so it is Romano and Alexandra Sergazinova. Mistreatment of a commission member. Okay, I will pay close attention to that. Okay, because it has effect on prisoners being able to file complaints. We have 6 minutes remaining. Let me summarize. Today we have received a number of recommendations. So the traditional means or mechanisms for handling complaints, they are enshrined in the Kazakhstan legislation, and many of them are used. However, there are issues when, for instance, an emergency provision is implemented, when there is natural disaster situation or an emergency, or maybe if we have warfare. So what do people do in that case? Who do they address? Because filing a complaint has direct relation to Article 16 on the right to protect oneself by any means, any legal means, and this has not been implemented effectively. So far, there have been no resolutions on Kazakhstan's implementation of this Article 16. However, thing we'll be discussing today is related to many rights. If one is unable to file a complaint to the agencies that's supposed to create conditions for the implementation of this particular right, for instance, for receiving food or maybe medical assistance. So there are many things you could complain about, and especially if it is vulnerable groups we're talking about, both Kazakhstan nationals and foreign citizens. If one is unable to file a complaint, it means that they have no means of protecting themselves and access to protection, being protected from torture and mistreatment, is the reason why the torture committee has been recommendations on and on this needing to be addressed, that it needs to change. We need to fine-tune these procedures, and we need to work on those case by case. For instance, if it is an emergency situation or a natural disaster, we need to see how it is related to other rights. And our recommendation is to enshrine in the legislation the right of a child to file a complaint to government agencies, because the president has signed and parliament passed third protocol to the Children's Rights Convention. So it means that even at an international level, children enjoy that right. They are able to file complaints to the Children's Rights Committee. But in our country, we do not have a mechanism like that, and we need to. Also, so not providing medical treatment could be seen as mistreatment or torture. And we know that people in detention, in places of deprivation of liberty, those are children, women, elderly. So we're not talking prisons per se, we're talking institutions in general. And for those, we need to have mechanisms that will be working based on the type of person to be kept in that institution, because you may have the boxes, but people will not file any complaint, will not use those. And I've been doing visits for 20 years, and I think it's been only once when I found something in the box, and that time it was a dead mouse, because people know that you file a complaint, you get in trouble, because it's very easy to get access to what's inside. So the vulnerable groups, they need to have mechanisms that would take into account their needs and the type of institution. As for UN resolutions, we have many of them saying that Kazakhstan's violating Article 13 and nothing's been implemented based on that. However, the standard is quite obvious. State is supposed to ensure a confidential and unhindered access to complaints mechanisms and complete privacy, and ensure that complaints are protected against any intimidation or reprisals. And we see that in Kazakhstan, we have had any government agency decision or paper saying that this issue has been resolved. So Kazakhstan has been in violation of this article for a long time. And it also says that state to ensure complaints are protected. And this is what was mentioned in the ruling of on the case Dmitry Rakishev versus Kazakhstan. Mr. Akshev died in detention in Uсть-Каменогорск. And it means that a number of violations have been recognized, but our government agencies have not responded. So we need to introduce one norm to our legislation. So one simple amendment. The courts need to have the right to address complaints based on UN agency resolutions, because currently the courts have no grounds for them to initiate a case. So this is the one norm that needs to be enshrined. Thank you very much indeed. I hope you saw the link that we sent you in chat. If necessary, I will send it to you again. This is about the key standards. This is the information our citizens need to be aware of. This is what they expect to, the rights they expected to enjoy in detention. And I would like to thank Elena Steinerte and Yaroslav Shturbo, our interpreter. As for our next discussion, we still have some paragraphs to address. We'll do it, have it in June. We'll give you further information via our social media profiles. How does one find us? Just type dignity.kz. Always give information on events we are to hold. We are interested in measures of legal protection, which is related to our discussion. Please remember that we hold online consultations with Mr. Lastayev, human rights ombudsperson, and we will have one on May 25th. You will be able to have a talk with Mr. Lastayev and to give your inputs. My hope is that Mr. Lastayev and Alexander, please forward our invitation, and we've already sent Mr. Lastayev an official invitation as well. So we'll be looking to meet him. So the meeting will be held on May 23rd at 11. May 23rd, 11 a.m. We'll be discussing criteria for assessing the effectiveness of ombudsperson's activities. Thank you very much indeed. Goodbye.